Now, what is our fear with this Constituent Assembly argument? It would be very difficult for this court to give a verdict on the Constituent Assembly being resurrected as far as the state of Kashmir is concerned, and in a future date, tell us that no, that's a principle that applies to Kashmir, it doesn't apply to the Constituent Assembly of India. My view is it applies squarely to the Constituent Assembly of India. There is no question of suddenly reviving or resurrecting the Constituent Assembly of India in any fashion. It's done for. What you want to do, you do by amending this constitution. This is something we and our forebears have tied ourselves down to. That's the idea behind the basic structure. There is no way of incremental modifications being made by virtue of resurrecting constituent assemblies. This case is effectively about, one, whether a power exists, and two, has the procedure laid down for the exercise of that power been followed? In Article 3, for example, there's a question that Justice Kaul put to Mr. Chandrachud Singh yesterday. Converting a state into union territory is a lack of source of power that doesn't exist in the constitution. It can't be done. But, subject to what Justice Kaul said yesterday, can you take a part of a state and convert it into union territory? Yes, you can. Article 3 provides for it, but there is a procedure for exercise of that power. That procedure has not been followed. I hope I'm making myself clear. So there's a source of power, whether it exists or not. And then there is the exercise of that power. The same argument applies to Article 370. Does the prospect of creating a constituent assembly exist today vis-a-vis Kashmir or vis-a-vis India? No. My answer is a square no. That's not provided for in the constitution, therefore it doesn't exist. In any event, and without prejudice to that argument, the exercise of the power and the manner of exercise of that power is one of the most fraudulent, invidious exercises that we have seen in this country since 1970. And why do I say 1970? In 1970, when they wanted to get rid of the Privy Purses, they moved a Constituent Assembly bill, amendment bill. That bill went to the Lok Sabha and passed through the Lok Sabha. It went to the Rajya Sabha and it was defeated by one vote. One vote. And then what did they do? Overnight, the president issues an order under Article 366, definition provision of the rulers, and uses that power to say from tomorrow onwards, there are no rulers, all your Privy Purses. What have they done differently today? They just use the next provision. They use 367. And your lordships came down like a ton of bricks on them. 9:2 you held against that kind of an action. And I want to show your lordships Madhavrao Sinha because I believe it squarely applies. They finally had to go back to the drawing board. They had to come with a constitutional amendment. That constitutional amendment was sustained in Raghunath Rao Ganpat Rao 20 years later. But the fact is, following procedures laid down in the constitution are sanctified mechanisms which protect us, which protect this constitution. The sovereignty doesn't go to the executive. The executive is a creature of the constitution, as is this court. The people are the sovereigns under our constitution. Let there be no doubt about that. Because I believe that there is some feeling, which is the same feeling that the government had at the time of Madhavrao Sinha, that some level of paramountcy, some level of sovereignty had devolved on the executive. So an executive has some residue power by which they will interpret the constitution differently. They will use definition clauses where they can't touch it directly. My Lord Justice Khanna on day one was considering the proviso to Article 370 and said, look, that's a proviso. But the proviso is perhaps the most important thing in this constitution. Constitution amendments in this country have been struck down on only two grounds. Only two. One was basic structure. The other was a proviso. The proviso in 368(2) was the reason why in Quixote Holohan, para 7 was struck down. Again, the amendments that were brought in for cooperative societies, your lordship struck down because it didn't meet with 368(2). I remember, my lord, the Chief Justice mentioning on day one about 368(2) proviso. Can you use that by way of the 356 route? I think that's a fantastic question. That's the heart of this case. Can you do that? Can you use 367? Can you use 366? Can you go sideways? The provisor provides the procedure you will follow, and you, creature and servant of the Constitution, will use no other procedure. We are not sitting here in deference to our equals. Our elected representatives have taken a choice. They've made a choice that they will follow the Constitution. Their oaths bind them to it. And they decide to follow devices like this. And they possibly don't learn from the lessons of the past. And I want to show your lordship the language of Justice Hidayatullah, Justice Shah in majority, Justice Hegde concurring in Madhya. It completely, in my view, covers this case fully. It's the exact same thing. In fact, it's less complicated, less experimental. But I'll come to that. That's the history part. On 370, because these words are very, very important in our Constitution. We can't read them as out of context specific provisions with specific words. The words temporary, the words consultation, concurrence, necessary, recommend, the non-obstante clause, even the colon. There are 3 colons in Article 370. All of these are found in other parts of the Constitution. So if your lordships were to look at this provision in isolation and interpret it without at the very least considering the other provisions where similar words are used, we would have a problem that will arise on a future date, which is why I want to address your lordships on those. Then on the frauds on the Constitution and the measures which keep those provisions intact. 3 of them in particular. The ordinance making powers, which are exceptional. The expressions your lordships have used are necessary evils, but with safeguards. And what is that safeguard? That it will be temporary. Immediately after the legislature comes in, the legislature will look at the ordinance and decide whether they want to continue or not, as they have done in recent weeks, as far as the NCT of Delhi is concerned. Article 356, about how it will be exercised. There are safeguards in the Constitution. And see the orders they pass under 356. They suspend the legislative assembly. Once they suspend, and suspend has no other meaning in law. It has absolutely no other meaning in law except that it is for a fixed time period. It's in the interregnum. It's between 2 things. I haven't terminated. I haven't ended, killed, murdered, paraded 9 feet, 6 feet under. I haven't done any of those things. It's just suspension. What is the effect of that order today? Exercising 356, they suspended the legislative assembly and poof, disappeared. What's happened to it? These are series of abuses of the Constitution which has taken place in this case. And finally, my lords, there is one aspect which I thought is interesting and disturbing at the same time. In 2018, coincidentally, just a month before the events which transpired here began, our friends across the border did something unusual. Pakistan occupied Kashmir, they have another name for it, and Gilgit-Baltistan are the 2 areas which Pakistan claims as its own. In their constitution, there's no reference to that as part of their territory. And I think advisedly so for their sake, because they still harbor some hopes that there would be some accession of Kashmir to them. In 2018, they decided, one, to pass an amendment to their 1974 interim constitution for, as they call it, Azad Kashmir. The other thing they did was, in the same month, they decided to pass a GO with reference to Gilgit-Baltistan, which is the other area which is also across the border, all part of erstwhile Kashmir, or continues to be part of Kashmir. In fact, Section 47 of the Jammu and Kashmir Constitution, you will find a reference that the territory of Kashmir as defined in the Constitution is the territory as it was on 15th August 1947, which is the entirety of it, without the 75,000 square kilometers having gone to Pakistan. Both those, that amendment and that order, what it did was to take away the right of self-governance. that the people in those two areas had and to vest it in themselves. As far as Gilgit-Baltistan is concerned, it was challenged with the High Court. High Court allowed the challenge. It was reversed by the Supreme Court, which strangely substituted the impugned order, which had been passed by the government, with an order of its own. Effectively, what the government there has done is to wrest direct control and vest it in a council with the Prime Minister. I ask myself that question, isn't India different? Are we not a democratic country run by a constitution? Do we not adhere to certain promises that we make and which are covenanted in the constitution as a solemn promise on which 5 constitution benches have weighed in? Or are we going to follow the ill-advised example of people who put their prime ministers in jail?